Hello, everyone. I'm here with Brian Green, the attorney, and I'm very excited about this interview for everyone that is in the immigration community. You've probably seen like in the past 48 hours, so I'm sort of like a good turmoil about the recent decision from the Nebraska court about an EB-1A case, which Brian, was the attorney responsible for that lawsuit. So Brian, thanks so much for joining us. If you can, just give like a little introduction about yourself, because one thing like I thought was very interesting, like browsing on LinkedIn is that you are an immigration attorney that is specialized in litigation, and
Yeah.
you know a lot of times like litigation is not even put on the table for petitioners in an immigration context. So, okay, yeah, I just want to, know a little bit more about you and how you got into like immigration and litigation.
Sure. I wanted to do immigration from law school onward, but it took me 7 years to get into it full time. So coming out of law school, I worked for a judge in the Pennsylvania State trial courts, and then I worked in Pittsburgh for General Electric Company, General Motors. I was working for a very good law firm that had a lot of big corporate clients, and I was their trial lawyer in Pennsylvania, West Virginia, sometimes in Ohio. And at that firm, I started doing immigration myself. And it was a transition going from litigation to doing more business immigration, family
Mhm.
immigration. And it was fun, but I needed to work. I want to do full time immigration. It's a complicated area that you really need to devote yourself to if you want to do it well.
Mhm.
So
Yeah.
I ended up doing immigration full time from 2007 until 2019. But even when I did that, I was doing mostly business immigration and family immigration. Even then, I was always doing the litigation cases, the writ of mandamus lawsuits, the delay lawsuits. And as time went on, I started doing more of the denial lawsuits.
Mhm.
So when I went solo in 2019, I had to make a business decision. Well, what kind of practice am I going to focus on? And if you know from the business immigration or the benefits immigration world, if you're going to do that kind of practice, you need 3, 4, 5 paralegals, you need
Yeah.
staff, you need an office. That's not really what I was trying to do. So I just decided I'm going to focus exclusively on U.S. District Court, trial court cases involving immigration. That lets me do that work from my home office here in Denver, and I have no staff whatsoever. The plus of that is that when clients call or email, they get me. The
Mhm.
downside is that there's a natural limit to how many cases I can take on, and I'm currently, really at that limit.
Yeah.
But my quality of work is extremely high because I'm not having a paralegal or a law student do the first draft. I'm doing
Mhm.
every single piece of legal work at a 24-year attorney level. I got the experience from the side where the cases were prepared. And
Mhm.
when you're litigating them at summary judgment in front of a judge, you really need to know how the cases were put together, how the evidence worked. Because what the judge in Nebraska, he didn't get into the actual details about the person's qualifications. He said
Yeah.
that, you know, Kazarian was illegal. Not to jump to the end
Yeah.
of the story, but I've had other judges where they go in and they actually look at the criteria and they're weighing
Yeah.
out the evidence. So in those cases, I'm very happy that I was the one physically putting together the package that got FedExed out
Mhm.
to USCIS. So after 24 years, I really enjoy working with people directly. And I also love being in court and arguing in front of judges. And when it comes to the actual court, I almost always have more experience than the DOJ lawyer on the other side. So that gives me a comfort zone on the substance of the case, but also I used to be in front of juries for felony criminal trials.
Mhm.
Arguing in front of a judge is less stressful than arguing in front of a. I mean, I love juries; they're great, but
Yeah.
what I do now in court is lower. I have less stress in court than I do in my home office.
Everybody in the community like wants to know like more details of
Mm-hmm.
the case that we're discussing. So I actually have the case here with me, and we can like go through like a few details. But yeah, if you can just give like a general overview of
Yeah.
like this case and what it represents, especially not just for lawyers but also for petitioners for in the EB1 area.
It's the biggest change in EB1 in the last No, I mean, I think EB-1 was either 1990 or 1991 when the law was passed and came into effect. So we've had
Yep.
it for 35, 37 years now. This might be the biggest change. Well, I think the biggest change was probably them adopting Kazarian.
Yeah.
And then this is the biggest change, except that it doesn't affect everybody. So this case is a lawsuit for an individual on
Mhm.
one denial. In her case, they granted, I can't remember if they may not have given her all three criteria the first time around, but eventually she, whether through the lawsuit or not, USCIS conceded that she had at least three criteria. So Miss
Yep.
Mukherjee is a international journalist. She was probably one of the best investigative journalists in India in history. And she came to the United States and was doing the work here and saying, and she said under EB-1, I am in the top 3 or top 5% in my field. Give me my EB-1 green card very quickly. And for Indians and Chinese, an EB-1 approval might mean getting your green card 20 or 30 years earlier than if you're waiting for EB-2 or EB-3. So
Oh
the
yeah.
reality is that many, many, many Indians and Chinese are applying for EB-1. They already have an approved EB-2 or EB-3 green card petition, and they are just trying to get, get their green card a generation earlier, which means that, another generation of their family probably become American citizens someday
Hmm.
versus at the pace right now, a lot of people are going to get their green card in retirement,
Yeah.
which is not the way the system was designed to work. But we have these, caps of like 7% per country. So
Hmm.
in the case in Nebraska, Mukherjee versus Miller, Lauren Miller is the director of the Nebraska Service Center.
Hmm.
USCIS did what I've seen has been the trend for the last 2 or 3 years. USCIS used to be really tough on a couple of the individual criteria for EB-1. They used to be really tough on original contribution.
Hmm.
They used to be unreasonably tough on high salary, even though most people in their high salary arguments were pointing to the Department of Labor surveys saying, hey, most people in this field make $140,000 and I'm making $630,000 a year. I'm obviously in the top percentile. It got to the point where people really needed to use a letter from an economist that would be independent evidence saying, I've looked at surveys, I've studied this, and this person's really in the top, 2% of their salaries. So there was a change a couple of years ago, and I think partially I'm to be credited for that change because I won a couple of lawsuits where the judges said that USCIS was being unreasonable in how they were weighing evidence in the step one process.
Mm.
And USCIS knows that the step two Kazarian final merits determination is a big mushy pile of something that it has really no standards involved.
Yeah.
So it's a lot easier for USCIS to say, well, we can see that you meet 4 or 5 criteria, but you really haven't made an international impact. Your research or your contributions haven't changed the way people do this all around the world. So we're going to deny it, saying that you haven't really shown that you're extraordinary in the sense that Congress intended. And there's not a way for judges to easily compare that to what would be the proper procedure or standard. So
Hmm.
USCIS started to deny a lot of these cases under step two. In my opinion, I think they did it because they think it would be easier for them to win in federal court on challenges against that step two denial. And I lost on the step two lawsuit in Philadelphia last year, Eastern District of Pennsylvania. And the judge there said that the Kazarian policy or standard wasn't a change. It wasn't really a legislative change. It was simply memorializing what USAS had always done from 1991 on. And I mean,
Hmm.
I respectfully disagree with the judge on that because I think there's a lot more denials since 2009 when USAS adopted the Kazarian memo. I think they use it as a way to deny more cases. If there really was no change, I think we would have seen, and I think we should do a FOIA and Freedom of Information Act request and see what the denial rates were, over 1991, 2009 versus 2009 to the present. I also lost once in Nebraska to a different judge, and I think I lost in the Northern District of Texas in Dallas, where the judge said that there's a decision called the Amin precedent. It's a Fifth Circuit decision. It says that, hey, in the Fifth Circuit, we're going to say that Kazarian's just fine. And ultimately, the Ninth Circuit issued the Kazarian decision back in 2010 or 11. Since then, people have tried to get it overturned, and the Ninth Circuit said, no, this is fine. So to put this into context, Kazarian decision from the Ninth Circuit was a district court case that denied relief to someone who had Mr. Kazarian had an EB-1 denied.
Hmm.
The district court did not have a policy or a way to say that this was proper. The Ninth Circuit invented it. The Ninth Circuit looked at it and said, well, the statute mentions this, these descriptions about people being extraordinary. We think that USCIS should go ahead and do this test and make it a second step. And USCIS thought, this is great. We're going to go ahead, adopt the Ninth Circuit decision, and we're going to adopt it nationwide, even though the Ninth Circuit covers, Oregon and Washington and Nevada and Idaho and California, Arizona, et cetera. They said, we're going to use this nationwide. And they published a memo internally saying, this is how we're going to decide cases going forward. The problem is that if you are changing people's rights under the law, you have to do it through notice and comment rulemaking. You actually have to publish the proposed rule in the Federal Register. You have to take public comments on it. You have to weigh those public comments, and you have to publish, usually you publish a proposed rule, and then months later you publish a final rule. There are rules under the Administrative Procedure Act that you're supposed to follow. And they said, we're not changing anyone's rights. We're just changing how officers are instructed on how to do what they've always been doing. And we disagree with whether that's true or not. One of the reasons we disagree with that is that back in 1995, the former Immigration and Naturalization Service, INS, back in 1995, they actually did publish a rule. They published a rule saying, we're going to adopt this second step analysis. There was no Kazarian name back then. But they ultimately didn't go through with it. They never finished the process and they let it go. So in my lawsuit, we told the judge, hey, judge, they knew this was a legislative change. This was a substantive change to people's rights because they went ahead and published it in 1995. And DOJ and USCIS, they don't like talking about that. They just kind of ignore that and say, well, that's just part of the history. It doesn't really matter. So what this means for my client is that USCIS has to make a decision now. They've got 60 days to file an appeal if they want to. The interesting thing here is that I thought I was going to win this case in Brooklyn or Philadelphia or in some place that is more thought of as being more of a liberal court. The district court in Nebraska is not liberal. They typically have Republican senators, and those senators help choose or act as gatekeepers for who gets selected as U.S. District Court judges. So the judge that made this decision is probably not someone you would think of as being a liberal judge. They're probably either a conservative or a middle ground judge. But the nice thing is that federal judges are appointed for life. So once they're confirmed by the Senate, they don't have to worry about politics anymore. So the judge did a really great job of analyzing the Administrative Procedure Act requirements, analyzing what INS did and what USCIS did, and he said that this is illegal. They changed people's substantive rights, and a denial in my client's case is set aside. So basically, if USCIS does not appeal, they have to reopen the I-140 and they have to re-adjudicate it using the pre-2009 standards that were included in the adjudicator's field manual, which is not used anymore, and any memos that the USCIS had published internally. So I'm expecting my client to get a new adjudication, and hopefully they say, yes, under the pre-Kazarian standard, you are an EB-1 person, you are approved.
I think really, really good information here. And I think as you said, this case for now, it applies only, for your clients, but can you envision that setting sort of like a default for other judges to see, the EB-1A framework
Absolutely.
differently, yeah.
Yeah, the judge here did an extraordinary job. And my colleagues who've read the case and discussed it with me say it's like a textbook analysis of APA requirements and how USCIS didn't follow them. So the judges are busy. A lot of judges will have, 1,000 cases on their docket. When a judge has done a really great job of setting out exactly what's required and what wasn't done, the facts are not going to change. I'm going to be filing hundreds of these lawsuits for people that have EB-2 denials. And I don't have to go into the analysis of why the denial was issued. I'm just simply saying, you use this formula for the denial, that formula is illegal. So
Mm,
everyone that has a step 2 denial can sue over this. And the district court denial or the decision in Nebraska is not precedent, but it's, I would call it very, very strong persuasive authority in Nebraska. I think now, because Nebraska Service Center is based in Lincoln, I think the judges in Nebraska are probably going to defer to this judge. Even if they are really conservative judges,
mm,
I think they're going to say, yeah, this analysis is really sound. I'm not going to come up with and put the work in to do a really good job on a conflicting decision. Why do a good
yeah,
job of work? Then we're going to have the Eighth Circuit decide between the two. It could go to the Supreme Court someday. Cases are going up and down. I think we're going to have, I have someone contacted me. They're in Arkansas. They're in Bentonville, Arkansas. I'm like, yeah, that's in the Eighth Circuit. Let's go ahead and use this case. I think it's persuasive authority across the whole country, and it's giving lawyers the roadmap about how
mhm,
to do the lawsuit and win effectively, and it's giving judges the roadmap of how to write their decision, saying yeah. And it's also easy. The judges don't have to get into the merits of the decision. They don't have to look at whether this person had 5 criteria, 4 criteria. They're looking at, is the process wrong or not? It's a very simple
yeah,
black and white issue. So the facts are not going to change. The arguments are not going to change anywhere in America. The only thing is, in the Ninth Circuit, there's the Kazarian standard precedent. In the Fifth Circuit, there's a Min precedent. Those two, I think people should wait and do their lawsuits later. I think we should
mm,
win in the Second Circuit, the First Circuit, the 11th Circuit. There's an appeal in the 11th Circuit right now. Mark Prada is a really incredible lawyer in Miami. He's using this decision in his appellate brief. So hopefully the
mm,
11th Circuit will reverse his client's loss in Florida, and then we would have a circuit and the 11th Circuit. I'm waiting for a decision from a judge in Brooklyn. That's the Second Circuit. So, and I filed the Mukherjee decision as a supplement to that judge. So hopefully that judge in Brooklyn will see this and say, "Yep, this is right. I'm going to use the same analysis to reach the same conclusion." So I think this is the crack in the dam that is going to lead to a lot more courts coming to the same conclusion. And the ironic or funny thing is that USCIS a couple of years ago switched over to denying under step 2. So they're making my
mhm,
job easy, because now there's 2 or 3 or 4 years of people that have this very black and white step 2 denial. If people are denied under step 1, this decision doesn't really help you. You need to sue under step 1, or you need to reapply and use
mm,
someone like your law firm to do a really good job on the EB-1 step 1 analysis. And if you sue under step 1, they may go ahead, reopen your case, concede 4 or 5 criteria, and then deny under step 2. If they're smart, they'll start denying under the old standard before Kazarian.
mm,
And they'll explicitly say, we dispute whether the Kazarian standard is illegal, but we're going to go ahead and apply the pre-2009 standard, and we're still going to deny you. If they do that, then you're going to be suing and just saying they did the analysis wrong. So I really think this is it's a big, big change, and I
mm.
think it's going to eventually lead to Kazarian, the case in the Ninth Circuit, being reversed.
And I know I have the decision here, like two things, that they're very interesting. Like towards the end, like they say, like, the court vacates, the agency's denial and remands the petition to the agency with instructions to approve the petition because there's nothing else, for the agency to do. So like
I
I think
agree.
that was brilliant.
We've always been arguing that there isn't a step 2. They've always been saying that if you meet the criteria, that should mean you are extraordinary. That if you meet 3 of the 10, that's what Congress, or at least that's
Yeah.
what the agency in their regulations said is extraordinary. They've invented a second step to deny some people. So by the court saying this, I'm hoping they just reopen and approve it, and
Mm.
then we ask for our Equal Access to Justice Act fees. But yeah, that's a really brilliant, strong order
Yeah.
from the judge.
And just to close, like our firm, like we work a lot with EB-2NW, and have you seen, we have our opinion, like, a lot has changed, especially, in 2025,
Mhm.
the way that, officers educate the processes. We call internally is like a pseudo Chawati, like where like
Right.
they say like, oh, we was in Chawati, but here you go, like we want like, beyond our reasonable doubts. So uh,
It's not fair. They're not doing preponderance. Preponderance should be
yeah,
51% likely, and
correct.
that's the lowest standard in U.S. law. This case doesn't affect that, but
Yeah.
you could certainly try to challenge the way that NIW cases are being denied. So if you challenge an individual NIW denial, most courts are going to deny or going to dismiss the case, saying that there's no jurisdiction to review discretionary decisions. And
Correct.
USCIS and their lawyers at DOJ will say, well, waiving the labor certification requirement is discretion, and Congress said that. But USCIS can make mistakes in things that are not discretionary. They could say, well, we're not going to give you the NIW, well, especially 45 context. I-45s, they will sometimes say, we're not going to give you the I-45 because you are inadmissible because you committed fraud.
Mhm.
That fraud decision is not discretionary. There's rules on how you reach that fraud decision. So you are able to sue in some situations, but your firm or me or someone else, you can sue over how policies are created or implemented. And if you can do a Freedom of Information Act and show that NIWs are being denied at a higher percentage, not a higher number, because we know a lot of people are filing NIWs now, but if you can show that they got denied at a higher rate, then you can argue that they are using, there's either a written or informal policy at USCIS to deny NIWs at a higher, with a
Mhm.
higher standard for proof. So I think there definitely is a chance to sue over that. It just doesn't come from this. This decision really is compartmentalized into the EB-1A
Yeah.
criteria. But NIWs certainly, I also think there probably is evidence out there. I don't have it yet that EB-1As for Indians and Chinese have been denied at a higher rate. So there
Mhm.
may be evidence that USCIS is engaging in national origin discrimination, and that if you are an EB-1 person from France or from Germany, you might get approved at a higher rate than someone who's from Chennai or someone who's from Guangzhou. So that's
Mhm.
another lawsuit in the future would be everyone that is from those countries might have a chance. The ultimate effect here, because the law just sort of changed with this Mukherjee decision. There's a case from the Supreme Court called Corner Post. It says that the 6-year statute of limitations for APA lawsuits doesn't apply if something changed that people didn't know they could sue earlier. So we can certainly file lawsuits for anyone going back to January 2020, guaranteed. I think we can file lawsuits for people from 2009 all the way to the present, because I think Corner Post, the Supreme Court decision, will let the courts look at this, because up until now, no one's ever said that the Kazarian standard was illegal under the APA. So
Yeah.
my invitation is anyone who has a step 2 analysis denial from 2009 to present, email me at Brian Green at greenusimmigration.com, or go to my website. My email is there. I'm taking on the cases, and I'll be filing them primarily in Nebraska or where people live. And I really want to win where people have a better chance with judges, where there's no circuit decision saying that Kazarian is okay.
It's awesome because not just for petitioners, but like other lawyers that, as I said, like most immigration lawyers, they don't really do litigation. But they can refer cases to you, like,
Yep.
with this, like this new decision, which is, as I said, like it was like really good turmoil in the immigration community.
We got some good news in 2026. It was nice to start the year this way.
That's great. That's great. Brian, thank you so much for your time, and hope to talk to you soon.
Thanks for the invitation.